The federal criminal case against Cliven, Ammon, and Ryan Bundy were dismissed. I am not affiliated with the U.S. Attorney's Office, nor am I in communication with them. I do not know if they are going to appeal the aspect of the dismissal that made the dismissal with prejudice. Even if the dismissal with prejudice withstands an appeal or it is not appealed, the underlying issue has not been resolved. The issue that has not been resolved is who owns the land that the Bundy cattle were grazing on. The Bundys have now filed a complaint in the Nevada State Court requesting that the state of Nevada intervene on their behalf to protect the Bundys from interference with their ranching operation. A copy of that complaint is at the end of this video. I have reviewed the complaint and it is with no legal merit. I have watched the Bundy videos. They have a stump speech, and the complaint in this matter is essentially their stump speech in writing. The most obvious reason to believe the case will not be successful is this picture. It is a picture of Larry Kagman asking for donations so it can be funded. If it had any chance of being successful, the Koch brothers and others would fund it. They are intelligent businessmen. They believe in return on investment. If there's no return, they aren't going to invest. The first legal mistake is that the third paragraph of the Bundy complaint alleges, as prescribed by the U.S. Constitution, Article 4, Section 3, the land was disposed of by U.S. Congress to the people of the territory of Nevada forming the state of Nevada, admitted to the Union of the United States in 1864. The Bundys walk around with pocket constitutions in their pockets. Their interpretation of the U.S. Constitution is so far off from the words of the Constitution that Ammon Bundy's attorney, Michael Arnold, had to make a video saying that in fact the constitutions they walk around with are the U.S. Constitution. I will now show you Article 4, Section 3 of the U.S. Constitution. Contrary to what the Bundys claim about being admitted to the Union means that all federally owned land in the territory becomes state-owned land when the state is admitted into the Union, those words are just not in Article 4, Section 3. Moving down to paragraph 4 of the complaint, they reference the Pollard's Lisi versus Hagen case. The situation of the Pollard's case is different from the situation of the Bundys. In the Pollard case, the federal government acquired the land in question from the states of Virginia and Georgia. The land in dispute with regards to the Bundys was acquired from Mexico by a treaty. The Pollard case said that when a territory becomes a state, the state gets all the navigable water which otherwise wasn't disposed of in the state and the soil under it. The Pollard-Lisi case also holds that we therefore think the United States hold the public land within the new states by force of deeds of cession and the statutes connected with them, and not by any municipal sovereignty which it may be supposed they possess. Effectively, the court is saying that the federal government can own land within a state, just as any other entity can own land within a state. In paragraph 5, they cite the Northwest Ordinance. The Northwest Ordinance predates the Constitution and is subservient to it. However, they left one important part out of the Northwest Ordinance, which reads as follows: the legislatures of those districts or new states shall never interfere with the primary disposal of the soil by the United States Congress, nor with any regulation Congress may find necessary for securing the title to the bona fide purchasers. That paragraph makes it abundantly clear that the federal government was to retain title to the land it had title to in a territory when that territory becomes a state. Paragraph 6 asserts that the state of Nevada never consented to having 85% of its land owned by the federal government. This is irrelevant fluff. The federal government acquired the land via a treaty with Mexico. The land was never acquired from Nevada, and it was acquired before Nevada became a state. Therefore, Nevada's approval is unnecessary. Going down to paragraph 10, they cite the case of the United States versus Gardner. And in one of the greater acts of legal legerdemain, they cite it because they claim it is wrong. I would recommend reading the case of U.S. versus Gardner. It is a very concise refutation of what the Bundys believe. It can be found at 107 F3D 1314. In paragraphs 12 to 15, they make some sort of equal footing argument. All states in the Union are inherently unequal. If you bought their argument that all states should be equal, then the state of Nevada would probably have to give up some land to the state of Rhode Island because the state of Rhode Island is so small, and the Great Lakes states would probably have to ship some water to the state of Nevada because the state of Nevada is a lot drier. Moving down to paragraph 31, they assert that the federal government does not own the land in question. They give no legal or factual support for that assertion. The land was acquired by a treaty with Mexico that is allowed for under Article 2, Section 2 of the U.S. Constitution. Article 6 of the U.S. Constitution makes treaties the supreme law of the land. Looking at paragraphs 33 and 34 and 35, the Bundys claim to have some rights to the land. However, from 1954 to 1993, either Cliven Bundy or his father before him paid grazing fees to the federal government on the land in question. That would have destroyed any claims they had of those rights. With regards to the water rights, if you don't use them in Nevada, they expire in 5 years. If you use water rights to give to livestock water, then you must have the permission of the people who own the surface. The Bundys did not have that permission. Paragraphs 36 and 37 assert that the federal government does not own the land. That is just false. In paragraphs 48, they make their Article 1, Section 8, Clause 17 argument. Clause 17 is about how the federal government can extinguish state law on land. There is no claim that state law was extinguished from the land that the Bundy's cattle were grazing on, so that is totally irrelevant. In paragraph 50, they cite NRS 321.56 to 321.599. This totally destroys their claim. NRS 321.599 says the right to enforce the provisions of NRS 321.96 to 321.599 inclusive rests exclusively with the Attorney General. They are not the Attorney General of Nevada, so they have no right to enforce NRS 321.596 to 321.599. In paragraph 63, they again assert the right to enforce under NRS 321.596 to 321.599. Again, this is, and again quoting NRS 321.599, the right to enforce the provisions of NRS 321.596 to 321.599 inclusive rests exclusively in the Attorney General, and they are not the Attorney General. In paragraph 69, he again reiterates his right to graze cattle. However, if the right even existed, they were extinguished by either he or his father paying grazing fees from 1954 to 1993. With regards to the relief they seek, item A cannot be granted because he is not the Attorney General of the state of Nevada, see NRS 321.599. B cannot be granted because the court cannot order the Attorney General to deal with NRS 321.596 to 321.599. C cannot be granted because Cliven Bundy is not the Nevada Attorney General. Since the Bundys are unable to cite law that supports their position, and since they are not the Nevada Attorney General, their attempts to get a declaratory judgment in this matter will crash and burn.